Do you know former State Trooper Michael Proctor?
I do.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
These text messages, I'm certain, hurt the government, but the government is trying to bend over backwards as hard as they can, because anything the defense is going to try and bring in is going to hurt the government, obviously. Well, hello, everybody, and welcome back to Buckle Up, It's the Law with Attorney Larry Foreman. Folks, we are in June, officially. We're in the defense's case in chief. We have already covered Disorga. Now we are doing Diamandis. Diamandis testified outside the presence of the jury under voir dire because judge no likey when defense calls witnesses that help their case and wants to hear what they're going to say before they say it. So she wants to get a preview for Hank Brennan. Oh, poor little Hanky. Needs a little preview so he can prepare for the defense. I mean, come on, dude. You know your case is horrible, and this is the only way he can prepare for it is by listening to their testimony before he listens to the testimony in front of the jury. So, without further ado, I bring you Jonathan Diamandis, direct examination by David Yannetti, because remember, this is now flipped. It is the defense's case, so they do the direct, and then followed by a brief cross by Brennan, and then by argument from both parties as to why he should or should not be saying the things that he is planning on saying. You'll see what I mean once you see it. Let's go.
Good afternoon, sir. Would you please state your name and spell your last name?
Jonathan Diamandis, Diamandis.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him, essentially?
Grew up with him, been friends for 30 years.
So you say you've known him since middle school, elementary school?
Yes.
Graduate high school with him?
Yes.
And are you friends after high school as well?
Yes.
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes.
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay. May I approach?
Yes. I think he's all set, Mr. Newman.
Thank you, Your Honor. Sir, have you reviewed that entire document?
Yes.
Does that look familiar to you?
Yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in? And if I suggested to you, it might be 4 from the end.
Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you type...
I have a different copy.
Oh, I'm sorry. It's for the record, it's on page... and for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
I mean, it could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
With regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
With regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
Does the text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Good morning.
Good morning. Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
Regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the these actually were emails, not text messages. Any of the emails that were admitted into evidence, nobody saw him do it, nobody saw him type it, and nobody discussed any of the emails with him. But the SJC cited a long-standing rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today. The appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch. It was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode, and he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor.
So for those of you who may be completely lost, I completely understand why, so let me shine some light for you all. Diamandis is a childhood friend of Proctor. There's a text exchange going back to 2022 that Diamandis was a part of, so was Proctor. The defense, including Yannetti, Jackson, Alessi, and Little, are trying to introduce the text messages into evidence for the jury to hear. Remember, the jury is not in the room when all of this is going on, including his testimony, Diamandis' testimony. The prosecution is objecting to the introduction of these text messages because Diamandis does not have a personal memory and a personal recollection of these text messages happening. But in order for the jury to hear the text messages, they must have a person who is a part of that text exchange in order to get those text messages introduced. Now, obviously, short of calling Michael Proctor himself and admitting to it himself, I don't know if the defense is going to do it or not, they're trying to introduce a portion of text messages which we still haven't even heard exactly what they are about because the jury is going to hear it more so. This is not for argument. There's no reason to introduce them by avowal for the defense. They are simply trying to make sure that this can come in the first place, and it sounds like it should. But the government is trying to bend over backwards as hard as they can to exclude as much, because anything the defense is going to try and bring in is going to hurt the government, obviously. And they know it. And these text messages, I'm certain, hurt the government. And we may have already found out today, the day that this video premieres, Diamandis may have already testified. Maybe he didn't. I don't know. I haven't finished. This is all, I'm watching this as a first impression for me. So this is all brand new. And you're getting my genuine reaction to all of this. So let's finish up. We still have about 15 minutes to go, maybe about 14 of actual video. And argument from, I imagine, both sides, and possibly a ruling. So maybe I will swallow my words back in just a few minutes, but let's see.
The Commonwealth, with regard to Commonwealth versus Welch, which is, again, cited in their memorandum, this opposition, Your Honor, they state what appear to be rock-solid, black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case, and in fact, the messages were let in, again, because of the circumstances and the content of the messages.
Typical deceptive prosecutorial tactics. DARVO, deflect, reverse, victim, and abuser. In this case, deflect, attack, and reverse case law and what it says. Nothing new.
Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where, there are times when, the police stop somebody on the street or the police get a search warrant and then they show up at a home. And rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites 3 principles. It's almost like they're setting a standard down that the court is supposed to follow with 3 factors. But again, none of the 3 principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes. Okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. Okay. So I won't even mention them then. The Commonwealth is.
She knows how bad they are. She knows how bad they are for Proctor and for the government. She knows it. He was about to say it, and she's like, don't. I'm going to exclude them. I don't want any mention of them. I don't want to hear what they say. I know what they say. I think she's leaning towards excluding them. I can already smell it in the water. Oh, please let me be wrong.
That we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has 3 components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them. Even the statement when Michael Proctor says that the homeowner's not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias. He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why. We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about, those are the statements he makes about Karen Reed.
I just figured something out, folks. They're not calling Proctor. The defense is not going to call Proctor. They're using proxies to introduce statements that Proctor made. That's why Diamandis is on the stand and not somebody else. They're not going to call Proctor. They're going to leave. They're going to show in closing arguments, folks, Proctor is so bad. The lead investigator in this case is so corrupt and bad and fired and no longer on the force that the government shied away from even calling him to the stand. That's how embarrassed they are by all of this. I can't wait for closings, folks, because remember, in opening, it was all Proctor, 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 and then we saw no Proctor anywhere. We just heard about him. His name was mentioned. His texts were mentioned. His this was mentioned. The fact that he's the lead investigator was mentioned. Buchanan tried to hide away from the fact that he was just a case officer rather than the lead investigator. Like, they're trying so hard, and by the end, the jury's going to be like, well, where is he? And he's nowhere to be found. The defense has no obligation to call him. This is the government's job, and the government's job is closed. So could they call him as a rebuttal witness? Sure, if there's going to be a rebuttal after the close of the defense's case. Is the defense going to call him? I am almost certain that they won't at this point. I think that's the dead giveaway right here.
In the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
And you can take care of it and email it in.
We'll do that. Thank you,
All right.
Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it. But there is no authenticity if he doesn't recognize them. The person that could best authenticate these text messages is Michael Proctor.
Okay, then call him.
This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yannetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue.
So when you call Buchanan to introduce and authenticate the text messages between him and Proctor, that's okay. But when you have Diamandis, who's privy to these text messages, and the defense wants to introduce them now, no. Verboten!
So authenticity, I don't believe this witness reaches that conclusion for them. Regarding admissibility.
And by the way, a lack of memory is not a condition precedent to the introduction of text messages that are memorialized in text format. FYI.
I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yannetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias.
No, you don't.
Because perhaps it did affect
So?
the bias.
Then
Perhaps
call him! Then call him as a witness! He's your witness, man! Are you kidding? You can't have your cake and eat it too. Pick one, Brennan. Pick one. This guy.
very biased and made decisions based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation. It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant?
It's not their
Is it
job.
material, and what is the value of it? I am not opposed to the admission
Okay.
of bias against
Okay.
a witness,
Okay.
especially a police officer.
Okay.
But it
Then
should
let him
be
in.
against that witness because they need to have the opportunity to admit, deny, define, accept, and
That's not what the case law says. You're making it up.
explain. By putting these messages in with sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has
Gaining
no context.
an advantage?
Suggesting it has a value
You mean exploring the truth is gaining an advantage now? Good to know, Brennan.
not been defined, and then, as Mr. Yannetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being omitted.
That's a you
I do have some
problem.
issue that it's
That's
really
your
not
problem.
in the context of Bowden.
If you have a problem with it, then call Michael Proctor as a rebuttal witness, and you fix everything, right? Or make it worse. But that's not the defense's problem that you have problems with your case, bro.
It doesn't have to do with the adequacy of a police
Oh my
investigation.
God.
It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and
Pot calling the kettle black. It invites manipulation. You've been manipulating this case from the beginning, and now you're trying to accuse the defense? Oh, that's rich. Oh, that's so rich.
invites a party on either side to portray this in a way that is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
They don't have
Nick,
to.
do you want to respond?
I know we're the hour's late from our, I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense
Exactly.
to determine which witness we want to use
Exactly.
to authenticate and admit text messages.
Exactly.
That's our choice.
Yes.
And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the
100%.
text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance.
Yep.
His arguments, Mr. Brennan's arguments, go to the weight,
Yes.
not the admissibility.
Yes. That's
He
what I was
is
going to say.
fully entitled to cross-examine this witness
Yes.
about all of the points that he raises.
Yes.
And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call
Yeah.
the lead investigator, but that's what's happened in this case.
Yep.
We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire
Yes.
closing argument.
Yes.
He is entitled to call Mr. Proctor in rebuttal.
Yes.
He has every right to call Mr. Proctor again.
Yes.
I would rest on that.
There you go. He said exactly what I predicted it. I knew it. I knew it. I knew it. I knew it. I hate you, Brennan. I hate you so much. You have no idea how much I hate you. And your desire to do what you're trying to do, no, and no. And I hope the judge denies your motion and Diamandis testify. Well, he probably would have already testified because it's Monday. So thank you all so much for watching. Don't forget to subscribe, and I will see you in the next video. Bye, everybody.